Hello, little tiny one. Hello, little teensy tiny one. Hi, everyone.
Good afternoon. How are you today?
Good, thank you. Okay, it's 2:30, so I'm going to start. I know some people will join as we go along. Before getting to the lectures, just a couple of bits of news. I initially said on the outline that for your second test, you can either do an essay or do the test. I've decided that instead of giving you that option on the second test, I'm going to give you that option on the final. So, so with respect to the next test, everybody will have to write that test. I can't remember the exact date it is. I think it's right at the end of this month. And then there'll be a final test in the exam period. I don't think that's been scheduled yet. But so at that time, you can either write the third test or you can write a research essay, and I'll get you material on that research. I'll give you some topics or a topic for that research essay next week. So is that clear enough? Everyone has to write their test for the second test, and on the third test, you will have a choice between writing a research essay, a short research essay, or that is about 5 pages, double-spaced typed, or writing a third test. The other thing is that I have to be, I'm away next Friday, so I was trying to think whether I'd record the lecture and just let you look at it on YouTube. But then I realized we're a bit ahead. So I think instead I'm just going to cancel class for next Friday because we've got lots of time. In fact, I think I'll still have to add a topic or two to fill us out for the term. It doesn't take as long to go through things on online because there's simply not as much discussion. So I don't tend to go on as many tangents, I guess, either when I'm teaching online as I might when I teach in person. So so that's the second thing. No class next Friday. So you're going to have an option to write an essay on the third assignment, not the second assignment, and there's going to be no class next Friday. There will be a class next Wednesday. Okay. That's not the one I want. Oh, come on. Why can't I get the one I want to share up there? Oh, sorry, folks. I don't know why I mess this up so often. There we go. Okay, perfect. So we're going to move on from fundamental freedoms to in section 2 of the charter and how it relates to section 1. And we're going to now look at equality rights for this class and the next one. We'll look at, I think we'll get to 3 cases today and then 3 cases next Wednesday. Excuse me. So the first case is Andrews versus the Law Society of British Columbia. And it's going to have to do with section 15 of the charter. Now, section 15 of the charter is the equality section. So 15.1 then sets out what your what it means by this. and then section 15.2 gives some leeway in 15.1. That didn't make it clear, but so 15.1 is every individual is equal before and under the law and has the right to equal protection and equal benefit of the law without discrimination, and in particular without discrimination based on race, national or ethnic origin, color, religion, sex, age, or mental or physical ability. Now, what section 15.2 adds is that you are allowed to engage in discriminatory practices if the object of those laws is the amelioration of conditions of disadvantaged individuals or groups, including those that are disadvantaged because of race, national, the same group that was listed in 15.1. So you're not allowed to discriminate on the basis of race, national or ethnic origin, sex, etc., unless you're trying to fix a problem of people who have been in one of those groups and the disadvantages from which they have suffered historically and continue to suffer. So is that clear? So you could have a program that, let's say, gave advantage to entrance into a university on the basis of one's race or the basis of one's sex. If there was evidence that people of certain races or people of certain sexes had been unfairly discriminated in the past, they've been unfairly disadvantaged in the past and continue to be now. So you could create programs of various different sorts, from quota systems to a whole bunch of other things. It would appear to be, these two subsections of section 15 would appear to be inconsistent, but they're actually not, or so the charter has it. Now, once again, we're going to see the importance of that first section of the Charter of Rights and Freedoms, because everything has to be checked against that first section of the charter. So if there is a violation, if somebody has been discriminated against, and it's not a discrimination that's allowed under 15.2, then you have to determine whether or not the state can justify the infringement or the discrimination subject to the reason that, because it's a reasonable limit prescribed in law, as can be demonstrably justified in a free and democratic society. So the same thing as we've seen in previous cases with respect to, for example, freedom of expression. You can curtail freedom of expression if that's a reasonable limit in a free and democratic society. So we're going to see similar stuff here. The particular case, Andrews, really isn't particularly important in this case. It's the discussion about section 15 that's made it an important case. The issue itself was rather a particular one. It didn't have really, in and of itself, broad application. It's whether Andrews, who was a landed immigrant but not a Canadian, could become a lawyer in British Columbia. It was the case that BC had stipulations in place that to become a lawyer in BC, you had to be a Canadian citizen. And Andrews took the British Columbia to court and said he was unfairly discriminated against because he was a landed immigrant. As I recall, he eventually won that case, and he won it on the basis of the discussion they have here. So that's the importance of this case, and that looks at section 15, the equality section of the Charter of Rights and Freedoms. It looked in particular at what we mean by what's often called the formal principle of justice or equality. Typically, principles of justice are broken into formal principles and distributive principles. So formal principles mean that, as Aristotle put it over 2,000 years ago, that you treat equals equally and unequals unequally. And you get into trouble if you treat equals the same as unequals, or as somebody different, and vice versa. So the substantive principles of justice typically talk about how you distribute the benefits and burdens in society. And there's all kinds of different ways of that, from a meritocracy to a Marxist system to anything in between. So, but here it's concentrating on that formal principle. It's also going to look at what a reasonable limit to equality is under Section 1 of the Charter. What do we mean by how much work should we give to Section 15 versus how much work we give to Section 1 in deciding cases of equality? That will become clearer as we go along. Seems stuffed up all of a sudden. I hope that's just a normal cold coming on or something. Actually, I hope it's just the sniffles. Okay, so when we say we need to treat everyone the same, treat equals equally, it does not mean treating everybody the exact same way. That seems counterintuitive until you think about it a little bit further. So think, for example, if your building, which is a public building, say at Cape Breton University, if the only way to get from one floor to another was walking upstairs, then that would, in a sense, treat everybody exactly the same, but it discriminates against people who have physical disabilities that makes it impossible or very difficult for them to get up and down stairs. So to not discriminate against anybody here, you have to give them all similar access to classroom spaces or office spaces or whatever it is. And that requires, in addition to stairs, something like an elevator or ramps or any way that would allow people with physical disabilities to access those spaces that they couldn't otherwise access. So not everybody, because of different circumstances, because of differences between them, will should be treated exactly the same. You have to make exceptions in some case in order to treat them the same. Another example that they talk about in this case was if you consider Hitler's laws against people of Jewish origin, and it treated all folks within a certain group, that is, it treated all Jews exactly the same, but that meant treating them all unjustly, I mean, to put it mildly. So it didn't discriminate against one Jew or another, but obviously it treated all Jews unjustly. A more recent case with that has implications certainly for pregnant women in our society is that there was a case, Bliss v. AG, where a pregnant woman was excluded from unemployment benefits, and the court ruled in that case that she wasn't treated unequally. She was treated equally, in fact, because all pregnant women were denied these benefits. So the group to which she belonged, as the court saw in this case, pregnant women, they were all treated the same. Now, they were all denied benefits that weren't denied to non-pregnant women or to men who can't get pregnant, but the court ruled that that was okay. Now, that case occurred before the Charter of Rights and Freedoms came into effect. That case after the Charter of Rights and Freedoms came into effect would obviously be declared discriminatory, unfairly, unjustly discriminatory. People sometimes forget that women working in large numbers outside of the home is something that really only started to be the norm rather than the exception from the 1960s and probably the 1970s, 80s onward. So it's a fairly recent phenomenon. And because of that, because there was such a huge social change that occurred, legislatures and courts simply weren't prepared for those changing social circumstances. So had all sorts of laws created that treated women differentially in what turned out to be completely unfair in unfair ways. And as we'll see, having a Canadian Charter of Rights and Freedoms really helped a lot of groups who seek redress and from discriminatory practices in the past. Women were often fired when they get pregnant, and that is no longer allowed. So, how do we treat equals equally? Well, the court is quite clear that there's no fixed test or formula that can be applied here. It's very contextual. So consideration, they say, must be given to the content of the law, the purpose of the law, its impact upon those to whom it applies, and also upon those to whom it excludes from its application. So we're going to have to look at cases in their context, not necessarily all one-on-one, because some cases will be similar enough to other ones to provide precedence, but it's simply not going to be the case that, you know, it's a formula like 2 + 2 = 4. It's just not going to be that precise, and it's going to be more contextual. In Canada, before we got the Charter of Rights and Freedoms in the 1970s, we started over a period of time building up provincial human rights codes, and then eventually a federal Canadian Bill of Rights. So before that time, before these bills of rights came into effect, discrimination was in fact fairly rampant. So if you were anything but a white male, your chances of being discriminated against in any number of ways was fairly well established and fairly common. So, but it was recognized over time that there was a need to develop these as more women entered the workforce, as we had people who were not of French or English ancestry in the country, as settler communities had to come to terms with their treatment of Indigenous peoples of Canada, as we started getting immigrants from other parts of Europe, other than France or the UK, and immigrants not from Europe, say from Asia, from Africa, and so on. My wife, for example, is of Italian and Czech background. Her parents were first-generation immigrants here. And my father-in-law told stories about when he went to school that if something was stolen, they just sort of lined up all the Italians and just assumed that it was one of those, one of them, sorry. So, and that's one group amongst many other groups who were unfairly discriminated against in our history. It's rather and not just unfortunate history, shameful, maybe. Some people would say that's too strong a word. Some people would say it's exactly right. But at any rate, Canada, like most countries, has had to come to terms with its discriminatory practices in the past and today. I mean, it continues to be a hot debate whether or not there is, given that there are individual examples of racism or sexism, is there racism or sexism in the system itself? And part of what the Black Lives Matter movement has tried to push is the idea that there's actually systemic racism against particularly Black people and in Canada, our Indigenous population, our First Nations, Inuit, and Métis peoples. So over time, we developed these provincial human rights codes, then a federal Canadian Bill of Rights. So how are we?
Sorry,
Yeah.
quick question.
Yeah.
Did any of those, like the Bill of Rights or the codes, did any of them deal with ageism, or is that something that's a little bit more modern, I guess?
That was more recent. Certainly, in my time working here, there were a number of people who did not want to retire at 65, who were forced to retire at 65. So it wasn't until the charter came into effect, and in fact, only until certain cases were heard at the Supreme Court level, that they eventually did away with mandatory retirement. And I think the court, if I remember correctly, and this is similar to some cases about, let's say, prostitution, when they found out that prostitution in the eyes of the Supreme Court, the laws around it were discriminatory and violated the security of person, then they gave the government, I think it was a year, to come up with a new law that did not violate the charter. Similar kind of thing happened with respect to medically assisted death. And I think that's what happened in with respect to ageism and mandatory retirement. Businesses and were given, and public agencies were given a time period in which the discriminatory practices were allowed until they could they could make that really huge change to an end to mandatory retirement. So that came with the charter, not with these individual human rights codes.
But assistant killing came with the case Latimer versus Canada, I guess. Assistant killing was that time given a right to it as the Latimer's case.
Oh, I think we're going to look at the Latimer case later in the term, but the Latimer case, it involves a father who euthanized his seriously disabled daughter. In that case, it wasn't a case of medically assisted death. It was, according to the courts, murder. Because she did not consent to it. In fact, she could not consent to it. So the Latimer case, the actions of Robert Latimer would still be considered illegal at this point in time, even now that Canada has medically assisted death. The other thing about the Latimer case is whether or not the punishment he received was fair, and so we'll certainly look at that when we go forward. It was actually other cases that that determined the medically assisted death. In both cases, one was that were very close. One that was anyway. It was somebody with Lou Gehrig's disease, ACLS. ALS, amyloidosis, I can never pronounce the name of it. Very horrific degenerative disease, and the arguments made there were that by the time people reached a state where they no longer would want to live, they would be incapable of committing suicide. And since suicide is not an illegal activity, they were preventing people from who with this particular disease and other similar ones from doing things that the rest of the population could do, and other arguments along that. Again, we're getting ahead of ourselves because we're going to get to that. In terms of discrimination and how we're going to define it in the human rights codes, and in fact, when we come to the charter, it's going to be when we make a distinction, and it doesn't have to be intentional, so it can be intentional or unintentional, but based on grounds relating to personal characteristics of the individual or the group, and which has the effect of imposing burdens, obligations, or disadvantages on such individual or group not imposed upon others, or which withholds or limits access to opportunities, benefits, and advantages available to other members of society. So it's not just that you've made a discrimination or a distinction between one individual and another, or one group and another, but it also has to be the case to be a discrimination rather than just a distinction, that it's imposed extra burdens on a particular group, or it's withheld certain opportunities, benefits from that particular group that does not apply to other people. Distinctions based on personal characters attributed to an individual solely on the basis of their association with a group will typically be discriminatory. Distinctions based on an individual's merits and capacities will typically not be classified as discrimination. We make distinctions between people all the time. So when you write a test, for example, I have to distinguish. I have to make a distinction upon the quality of the work handed in to me. So some people get a higher mark than other people get. That's perfectly okay because I'm basing that on individuals' merits and capacities. But if I did something like, oh, I'm going to give higher marks to men than to women, or the reverse, or I'm going to give higher marks to domestic students than international students, or vice versa, then that would be to make a distinction that also amounts to unfair discrimination, because I've imposed burdens on one group not available to another, or I've limited access to opportunities and so on. So a couple of parts there. Distinctions are drawn, but the distinctions have to be harmful and based upon group membership rather than individual talents. Obviously, it would be hard to imagine a society where we didn't distinguish between people on the basis of their individual merits. The Equality, Rights, and Human Rights Codes versus the Charter, there are some important differences here. In one way, the Human Rights Codes are far more broad in scope than the Charter Rights of Equality. The Charter Rights of Equality really only apply to discrimination under the application of the law, whereas human rights codes can apply almost everywhere. So, for example, in housing, and so on. So so human rights codes are broader in scope. On the other hand, human rights codes give an exhaustive list of the type of discrimination that they've decided to rule on. We're going to see how that applies in the Vren case later on in this class. In that case, we're going to find that the Human Rights Code in Alberta did not list sexual orientation as one of the ways you could be unfairly discriminated against. But because human rights codes are taken to have an exhaustive list of types of discrimination, and because sexual orientation wasn't there, they ruled that a man being fired on the basis of him being gay did not violate the Alberta Human Rights Code. The charter is much different because what they provide there, the list that they provide, is not exhaustive. So when we go back to 15.1, every individual is equal before the law, blah, 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 and in particular, based on race, nationality, or ethnic origin, all the things listed here, from race to disability, that's not meant to be an exhaustive list. so you can add other things on there, and what we saw in the Bren case and a little earlier in another case about sexual orientation is that you can read in a sense, other analogous types of discriminatory practices or discrimination against a particular group, and in that case, sexual orientation, then came to have the same status as all of these ones listed here. So just as you can't now distinguish or discriminate against somebody on the basis of their race, you can no longer discriminate against them under law on the basis of their sexual orientation. So does everyone see that difference between charter and human rights codes? If a human rights code doesn't mention something specifically, you can't assume or you can't read it in. In Charter of Rights and Freedoms, you can. Okay. The rights and freedoms in the Charter are less absolute than the ones in human rights codes. And that's because, as we've seen already, because of Section 1, which says that you can infringe upon or violate one of the Charter rights or freedoms if doing so is a reasonable limit in a free and democratic society. And so we've seen how the freedom of expression in Canada is not an absolute right. It's contingent upon what's reasonable in a free and democratic society. So hate speech and certain kinds of pornographic material we've seen in previous cases, restrictions against those are reasonable according to the Supreme Court on the basis of this section 1 of the Charter of Rights and Freedoms. Okay, and so the way it works is that, that's different than, for example, equality and discrimination codes in things like the U.S. Constitution and the European Convention of the Human Rights. The Canadian Charter of Rights and Freedoms is unusual, singular. I don't know if it's quite singular, but it's different than an awful lot of other codes in that it's the rights specified in it are conditional rights, conditional upon interpretation of Section 1 of the Canadian Charter of Rights and Freedoms. The way in which that works is that the citizen had an individual or an individual representing a group has to establish that his or her charter right has been infringed upon. In the cases we've looked at so far with freedom of expression, that was, those were clear. Keegster, for example, had his rights of free expression, his views about and what he wanted to say about Jewish people and the Holocaust. By not allowing him to say that in class, it's quite clear he had his freedom of expression infringed upon. So that's what has to be done first. Then the onus of proof is on the state, on the Crown, to show that restriction on that charter right, in this case, freedom of expression, is justifiable. That's going to work the same way with the equality legislation. So an individual has to prove that that they have been unfairly discriminated against, that there's been a violation of Section 15, in this case, of the Charter of Rights and Freedoms. And then if the state still wants to push that discriminatory law, they have to show, according to Section 1 of the Charter of Rights and Freedoms, that it's a justifiable infringement. Now, the last thing that happens in this particular case is there's a discussion about 3 different ways of noting the relationship between Section 15, subsection 1, and Section 1 of the Charter. And it really is how much work you're going to give to Section 1 and how much work you're going to give to Section 15.1. I'm just going to say 15 because it confuses things if I say 15.1 and then distinguish that from Section 1. So one way to do it is to suggest that it basically says, let's make it really, really, really easy to prove that discrimination has occurred under Section 15. Because we're going to basically say that any distinction made between people amounts to discrimination. And then very, very low hurdle to cross to prove, for a citizen to prove discrimination under this way of approaching the issue. Then it's left to all the interpretive work is done with respect to considering Section 1, if that discrimination is consistent with a free and democratic society. Another one by a different justice, Justice McLaughlin, is that no, we're going to do all the interpretive work in differentiating between distinction and discrimination in Section 15 of the Charter. And then there's going to be very, very little, if anything, left over for Section 1 of the Charter to do. Both of those, the court here rejects in favor of an approach that's called the enumerated and analogous grounds approach. And so I think in this particular case with Andrews that he was allowed to show that he could prove that he was discriminated against, even though landed immigrant status wasn't listed in the Human Rights Code or in the Charter. It was thought to be analogous to the groups that were listed in Section 15 of the Charter of Rights and Freedoms. We'll see how that happens more clearly in the Vrend case, not the next case we're going to look at, but the one after that. That's it for that one. Does anyone have any questions or comments? Okay, let's go on to the next case. And
This is maybe too simplistic, but it definitely feels like the Charter is more of a framework for answering questions than a place you go to for specific answers.
I don't think that's simplistic at all. I mean, one way to say it, I guess, is that life is incredibly complicated and complex. And if we had a set of rules that could be applied completely in a completely formulaic way, we wouldn't get at the truth or the fairness of the matter. So having said that, however, the Canadian Charter of Rights and Freedoms is distinct in that Section 1, because once you prove a right's been violated, then you can always then go to almost appeal it, as it were, to whether or not that infringement is justifiable according to Section 1. The other really weird thing about the Canadian Constitution and the Canadian Charter of Rights and Freedoms is this notwithstanding clause that we haven't looked at, but I mentioned it, I think, in when we talked briefly about the Charter in general. And that's where in certain, not for all rights and freedoms, but for certain ones, a government can invoke the notwithstanding clause and say, well, notwithstanding that this legislation we just passed infringes upon some sort of right in the charter, we're going to do it anyway because we're an elected body. And that is different than most charters or constitutions, because in a way, that's what charters of rights and freedoms are supposed to do, to limit the power of a majority, which is all a government is. It's the majority at that particular moment in time. So that's an odd one. And that, I think, is the product of Canada's kind of odd history, in that provinces have power, and in order to get a Charter of Rights and Freedoms, all the provinces had to agree to it. And there were certain provinces, Quebec in particular, that simply were not going to agree to have the same rules that apply everywhere else necessarily apply in Quebec. They were particularly concerned at that time about French language rules. So yeah, the issue is it is complex, and there's as you put it, I think, a framework rather than a place you go and say, I found the right clause and now I know that this applies, rather than that. It's not, though, that we're the only country that has that. If you think about the United States, for example, so you may know right now that a Supreme Court justice in the States, Ruth Bader Ginsburg, just passed away. And the States has this odd thing where it's a life appointment. It used to be that way in Canada, but now there's an age limit on that. Why that's not inconsistent with the charter, I'm not quite sure. But I don't know how old you are, but maybe you can go to 70, 75. But you don't get the weird thing here where they, you're waiting for somebody to die to put somebody else in for the rest of their life. But it's a huge debate now in the States every time a Supreme Court opening comes up, because one party wants somebody who's going to interpret the Constitution one way and somebody else is going to interpret it another way. So I think the United States Supreme Court has become way too political. But there's certainly room then for interpretation in any of these, in any set of laws. There's room for interpretation. I guess in a sense that's why we have lawyers and judges. So we wouldn't maybe need them if everything was more clear cut. Does that answer your question at all? Let me share screen. I don't know why I cannot remember how to do this. So I want to share a screen. I want to share this. Portion of screen. Oh my. What? Oh, sorry, I'm talking to myself. I seem to do, I have no idea what I do right or what I do wrong when I share a screen. So share screen. Okay, basic. Share. Ah. So you guys can't see that, is that correct? You can't see the PowerPoint?
Yeah, there's nothing.
Yeah. So what am I doing wrong? So I want to share screen and say that share screen. Then we go to share, and then it goes to this thing. Ah, there we go. Okay. I guess all I had to do was click on the PowerPoint at the bottom. Sorry about that. You'd think, what is it, 4 or 5 weeks in, I'd have that down by now. I also don't know why, but I've lost the last 2 recordings. I just, when I went to, after the class, it takes a while to, whatever it does to go through the recording and I don't know, turn it into some sort of file or not. And if I forget to come back, you know, that evening or, you know, within an hour or so, it seems to disappear. So anyway, so there are no recordings of the last 2 lectures. Sorry about that. Okay, so the next case we're going to look at is Eaton v. Brant County Board of Education. And this was a case that had to do with a young girl. I think she was 12 years old, Emily Eaton. She had fairly severe cerebral palsy. And she had a great deal of difficulty, not just in walking, but a great deal of difficulty communicating. So cerebral palsy, as you may know, affects people differentially. So some people have milder cases than another. And certainly a lot of cerebral palsy, people afflicted with cerebral palsy can be mainstreamed in school with, you know, no particular difficulties at all, or very few. Some of them don't even need, you know, a special educational assistant or anything in the classroom. Some do and can get by with that extra help. And then you get cases like Emily, whose affliction was very severe. So she couldn't speak, and she really couldn't communicate in any other way. Her parents wanted her mainstreamed in a regular classroom, and she was in a regular classroom for 3 years. And at that time, the school board did an assessment of her and argued that Emily was actually more isolated and less integrated in a regular classroom than she would be in a special ed class. So the school board were unilaterally decided to put her back into a special ed class, and her parents disagreed with that, and that made it to the Ontario Court of Appeal, and that Court of Appeal decided that Emily's being placed in the special ed class did indeed violate her section 15 equality rights, non-discrimination rights, and the argument was that putting her in that class was based upon a distinction, or made a distinction based on Emily's disability. Disability is actually listed in or enumerated in section 15.1. So that was the case. Eventually, it got to the Supreme Court of Canada. Anyone want to say what happened in this case? What the court eventually ruled and why, rather than me saying it? I guess I haven't done that before, so I put everybody on the spot. But well, there's a background. So there was an Education Act, and again, you folks won't be old enough to remember this, assuming that you're all went to school post 1980. When I went to school, I graduated high school before 1980. So we certainly had no people in, we had no special education people in our classes, or people with physical or mental disabilities in our classes at all. And the school typically would not have a special ed class for any students at all. So if students, say if you were mentally challenged, if you went to school at all, it would be in a separate institution, not just a separate classroom. So when 1980 Education Act came along, it mandated that school boards had to have special ed programs. And they also suggested that it would be better, if possible, to mainstream a student than to have them in a special ed program. Two things. There's special ed programs for those who cannot be mainstreamed into a classroom, and the idea that it was desirable to integrate as many people, as many students as you can into a classroom and not institutionalize them. That was the situation post 1980. And of course, by now, the Charter of Rights and Freedoms has come into effect. So we have cases like the one with Emily here. So here then it comes down to how we're going to interpret this distinction and whether the distinction amounts to a discrimination, unfair discrimination. And what the Supreme Court is going to suggest here is that not every distinction on a prohibited, even if it's on a prohibited ground, because certainly Section 15.1 talks about physical or mental disabilities, which Emily has, so it is a prohibited ground. But even there, not every distinction made for people amounts to discrimination. The real key here will be, according to this Supreme Court decision, is whether or not you're looking at the actual characteristics of the person involved, or whether you're relying on stereotypes. If you're relying on stereotypes about, oh my goodness, somebody who's Down syndrome could never be in a regular classroom, or somebody with cerebral palsy could never be in a regular classroom. So long as you're not making that stereotypical judgment, but looking at the actual person and their particular abilities, then if you're doing the latter, if you're looking at particularities and not stereotypes, then it may well be the case that you're making a distinction that is not a discrimination. Why is that? Why does the court maintain that it's a distinction without discrimination? Well, remember, they're defining discrimination not just as a distinction, but one that has adverse effects on the person being distinguished. So in this case, it's not just that Emily is going to be looked upon in a stereotypical way as somebody suffering from cerebral palsy. They're going to have to look at her particular abilities or disabilities and see if having her in a mainstreamed into a regular class, even with all the help she was getting there, or to place her in a special ed class would be better for her. So they eventually decided, look, integration's the norm. That's what we would like to do, if possible, but it's not always in the child's best interest, given certain particularities of an individual case, to have them follow that norm. So for them, not to follow that norm, not to integrate them into a mainstream classroom is not necessarily a violation of their of section 15.1. And they ruled that Emily's case, given the evidence they had from the assessment done of her, that Emily was a case like that. So she was not unfairly discriminated against. She was actually better off in a special ed class than she was mainstreamed into a regular class. Anyone have any questions or comments about that? Okay. Let's stop sharing that. I don't know if I'm going to have time to get through the next case, so I think I might end it there. The next case deals with, I mentioned it before, about a man in Alberta who was fired because he came out, I guess. And so this was an important case in the history of the rights of GLBTQ plus folks in Canada. So we're going to pick that one up next Wednesday. Does anyone have any questions or comments they'd like to make before we call it a day? Okay, well, it's Thanksgiving weekend, which means a holiday on Monday. So everybody, I hope you enjoy your holiday weekend and stay safe. Don't gather in too big a group, and practice your social distancing and all of that sort of thing. But take care and have a great weekend. And I'll see you next Wednesday. Bye-bye.